Good afternoon. In honor of Black History Month, and as part of our ongoing series, Race and the Law, today we're having a panel discussion on the enormously important topic of race in the legal profession. And we really couldn't have better speakers to address this. I'm going to do very short introductions of the four speakers, and I apologize in advance that they are short introductions, because we spend the entire hour and 10 minutes just going through their credentials. And then we'll hear from them one at a time, and then there'll be time at the end for questions. The first speaker, Professor Elizabeth Gorman, she's Professor of Sociology at the University of Virginia, PhD in Sociology from Harvard, a JD from the University of Chicago, and she's written extensively about race in the legal profession. The second speaker is, of course, someone very familiar to us at Berkeley Law, Justice Goodwin, Justice on the California Supreme Court. He clerked for David Tatel on the DC Circuit and Ruth Bader Ginsburg on the Supreme Court. He then spent many years as a professor and associate dean here at Berkeley Law before becoming a justice on the California Supreme Court. It's hard to believe that it's a decade now that he's been Justice Lou on the California Supreme Court. Third, I want to introduce Luis Rodriguez. Luis is the son of Mexican immigrants. He's the first in his family to go to college and law school. He was an undergraduate in law degrees from Santa Clara University. For the last 26 years, he's fought for the right of indigent individuals in Los Angeles County Public Defender's Office. Currently, he's the executive manager overseeing the juvenile division. He has served in many leadership roles. He's the first and only public defender and Latino to serve as president of the California State Bar. The final speaker will be Professor David Wilkins, who's a Lester Kissel Professor of Law at Harvard Law School. He clerked for Thurgood Marshall on the Supreme Court. After time in private practice, became a professor at Harvard Law School. He's a leading expert on the legal profession and has also written extensively about the issues of race in the legal profession. And I have to also say, David was my high school debate partner a long time ago.
Wow.
So with those as introductions, I'll turn this over to Professor Gorman.
All right. Well, thank you very much. I'm really delighted to be here today. I'm going to focus on racial and ethnic inequality in the large law firm segment of the legal profession. So over the last 25 years, the representation of people of color in large law firms has slowly increased, but we continue to see a pattern in which the presence of people of color is fairly high at lower firm levels and then drops off markedly in more senior positions. So according to a recent report by the National Association for Law Placement, in 2020, in the average large law firm, people of color constituted about 36% of summer associates, 26% of regular associates, 12% of counsel, and 10% of partners. So I'm going to offer a framework for thinking about racial ethnic differences in getting ahead in law firms. And this will be a bit of a 30,000-foot overview. So I apologize in advance for skipping over many important details. Getting ahead occurs through hiring, promotion, and allocation of responsibilities and authority. In other words, through a series of selection processes. So we can think of each selection process as involving two actors, a candidate and an employer or firm acting through its designated representatives. And each actor has a decision to make. The candidate decides whether to apply or otherwise indicate interest in the role in question, and the firm decides whether to select the candidate for the role. So this stylized model applies to selection processes at every level, but I'm going to focus on promotion from associate to a senior position in the firm. And I'll use the term senior position to encompass the variety of permanent senior roles that most large law firms now have, including various counsel positions, non-equity partners, and equity partners. Now, I'm not aware of any research tending to show racial or ethnic differences in interest in attaining senior law firm positions, at least not when new lawyers first enter their firms. We do know that associates of color leave law firms at higher rates than whites do. But I would argue that this higher attrition largely reflects these associates anticipation of a negative decision by the firm, right, which they decide not to wait around for. So I'm going to focus on the decisions made by the employers, in other words, the firms. And at this point, I'm going to share my screen because I think a few diagrams may be helpful. Okay. So in selecting employers for senior positions, firms look for specific attributes, which tend to fall into three broad categories. And I'll call those categories professional ability, cultural proficiency, and network ties. Now, in this kind of diagram, which we use a lot in sociology, the arrows represent theorized causal relationships. So, for example, the arrow from professional ability to promotion means that lawyers with greater professional ability are more likely to be promoted to a senior role. Now, by professional ability, I mean competence at all the tasks that lawyers are called upon to do, ranging from expertise on arcane legal issues to much more practical skill at managing client relationships. Now, selection on these kinds of cognitive and practical skills is usually considered legitimate in our meritocratic society, but the other two categories are often seen as a bit more questionable. Cultural proficiency means mastery of cultural norms, values, meanings that prevail in a particular firm. In most large firms, this culture reflects the culture of the elite segments of the broader society. Research has shown that law firms and other professional firms deliberately hire new associates based on cultural fit. So this screening on cultural proficiency at entry may mean that it plays a smaller role at the point of promotion to a senior role. As for social network ties, right, in law firms as elsewhere, success depends not only on what you know, but also on who you know. So ties to a powerful mentor and other allies in the firm may be essential to getting ahead. Ties to friends and acquaintances outside the firm may be valued for their business potential. Let's see. Oops, there we go. Okay. So professional ability, cultural proficiency, and network ties don't appear out of thin air, right? So although innate talent and law school education no doubt play some role, in law firms, these attributes are largely acquired in the workplace through mentoring, skill building assignments, and other developmental experiences. So this is the royal jelly that Wilkins and Galati famously discussed in their well-known 1996 paper, right? If a bee larva is fed this rich nutrient, it will develop into a queen. If not, it will develop into a worker bee, right? Similarly, if an associate receives developmental experiences, they'll develop into a lawyer capable of functioning at senior levels. If not, they'll flatline at a lower skill level. All right, so how does race come into this picture? Well, in the research literature, possible explanations for racial and other forms of workplace inequality tend to fall into two broad categories. One that points to differences among employees and one that points to bias and discrimination by employers. There we go. Okay, so let's consider the first type of explanation. Are there racial and ethnic differences on average, such that whites tend to score higher on professional ability, cultural proficiency, or network ties at the time of selection for a senior position? So in this figure, let's say that these direct arrows from race, ethnicity to valued attributes represent potential group differences that are not due to developmental experiences in the firm. Or in other words, differences that largely arise prior to entry into the firm. Now, to my knowledge, there's no evidence that whites have stronger professional skills than people of color upon entry into law firms. New lawyers of all races typically have the same level of education, a JD degree, and the same lack of practical experience. So we'll take that arrow away. Here we go. Now, turning to cultural proficiency, to the extent that lawyers of color come from socioeconomically disadvantaged or immigrant backgrounds, it's possible that they'd be less familiar with the organizational cultures that largely reflect white, native-born, middle or upper middle class social worlds. But even so, there's at least some research indicating that by the time professionals of color have navigated their way through college and professional school, they've been pretty thoroughly socialized. So I think we can take that one away as well. With respect to social network ties, there is at least anecdotal evidence that lawyers of color are less likely to have contacts in positions of power and influence outside the firm. Why? Well, mainly because they tend to have fewer white people in their social networks. So we'll leave that arrow in. But as we said earlier, these valued attributes are largely acquired after entry to the firm. So, and much of that acquisition occurs informally through mentoring and other developmental experiences. Now, research shows that it's more difficult for lawyers of color to gain access to these developmental experiences than it is for white lawyers. So we know that senior lawyers who are in a position to offer mentoring and sponsorship tend to gravitate towards proteges who are socially similar to themselves or who are perceived as rising stars. And due to biases that I'll discuss in a moment, these proteges are likely to be white. So we'll add in an arrow there. So lawyers of color are less likely to get that royal jelly. And as a result, by the time associates are considered for senior positions, it is possible that whites may, in fact, demonstrate a stronger set of skills than their counterparts of color. Now let's look at the second type of explanation. So firms may evaluate their associates of color less positively due to unconscious or conscious racial and ethnic bias. Right? And this direct line from race ethnicity to promotion is meant to represent this bias. And now the extent of this bias depends on characteristics of the employer and of the job in question. Psychologists have identified two kinds of bias: in-group preference and stereotype-based bias. Now, in-group preference, that means that decision makers tend to favor their own group over other groups. This may be intentional or it may be unintentional. Unfortunately, people seem to be predisposed to feel more comfortable with members of their own group. In any event, the negative impact of bias for lawyers of color will be greater when the decision makers are predominantly white. The other type of bias, stereotype-based bias, does not necessarily depend on the race or ethnicity of the decision maker. So all of us live in the broader culture and are aware of the stereotypes applied to our own groups. Psychology tells us that our brains are hardwired to categorize things and to create mental models, the typical member of each category. And we then perceive individuals as more similar to other category stereotypes than they really are. However, the impact of this stereotype-based bias is going to depend on the selection criteria for the position in question. A candidate will appear to be a better fit for a position to the extent that the candidate's group stereotype matches the decision maker's perception of what is needed for the job. So this type of bias will affect specific racial ethnic groups differently because the stereotypes associated with these groups are different. So for example, a firm might look for aggressiveness in a litigation partner, but in a tax partner, they might look for orientation to detail. So if aggressiveness is part of a group stereotype, an individual from that group might actually be favored for a litigation position, but disfavored for a tax position. All right, so that's the overview, and I'll stop screen sharing here. And now I hope I have a minute or two left. I'd like to briefly return to the question of racial and ethnic differences in developmental experiences. So in a paper that I recently published with my co-author, Fiona Kay, we asked whether law firms' skill development policies and practices could make a difference for lawyers of color. In recent years, law firms have become increasingly deliberate about the process of associate skill development. And in our study, we examined 5 relatively widespread practices and policies: formal training programs, formal mentoring programs, assignment rotation systems, early responsibility policies, and broad statements of commitment to professional development. And we also looked at the length of the partnership track, since that defines the period of time in which valued attributes need to be acquired and demonstrated. So essentially, we wondered whether any of these practices and policies benefit associates of color, either by substituting for informal developmental experiences or by encouraging senior lawyers to make those experiences more widely available. We looked at data on 600 offices of large US law firms to see whether the presence or addition of a practice was related to the numbers of Black, Latinx, or Asian American partners at a later point in time. To make a long story short, we found striking differences among the 3 groups, which suggests that the dynamics for the 3 groups are different. And in particular, we found no effects at all for Asian Americans. For African Americans and Latinx lawyers, we did find some positive effects. So formal mentoring programs and longer partnership tracks led to larger proportions of Black partners, while early responsibility policies were linked to larger proportions of Latinx partners. Now, perhaps counterintuitively, we also found some negative effects. So first, formal training programs, probably the most popular of these policies, right, were associated with smaller proportions of Black partners at time 2. And even more surprisingly, perhaps, broad statements of the value the firm placed on professional development were linked to smaller proportions of both Black and Latinx partners. So clearly more research needs to be done, but it seems that in designing their professional development practices, firms should give careful consideration to the potential impacts on lawyer diversity. I'll stop there. Thank you.
Wonderful. Thank you so much for having me, Dean Chemerinsky, and it's always a delight to be back with the Berkeley Law community. It's an honor to be on this panel with my fellow panelists. I think our comments are all going to dovetail quite nicely. I'd like to say a few words today about the general topic of implicit bias. And it's something that I've been very involved with for quite a few years now. And currently I co-chair a National Academy of Sciences working group that is going to have a multidisciplinary workshop in about 3 weeks, reviewing the literature basically on implicit bias and trying to come to some sort of evidence base about potential interventions. And so that's what I've been steeped in for a while. And I thought I would just share with you some slides that I've prepared in that context. This is going to be somewhat wide-ranging, not limited to the legal profession, but it's meant to give us a common base of understanding about some of the evidence behind implicit bias. And some of the experiments and findings are just kind of interesting in their own right. So let me just start here. Many of these concepts are already familiar to many of you, but I'll go kind of quickly and try to get us to the experiment. So what is implicit bias? Well, it refers to, stereotypes, attitudes that affect decision-making, often, or definitionally, I should say, involuntarily without our awareness or intentional control. So that's why it's called implicit or sometimes unconscious bias. This is just, in some sense, it's our normal mind at work, the way we categorize information, the way we make mental shortcuts. We couldn't really process the world without these kinds of mental schema. But the problem is that sometimes these generalizations can have deleterious social consequences, and we have to be aware of that. Here are some kind of little cartoon suggestive drawings of what implicit bias kind of looks like. You have to think of the bubble here as the unconscious thought of the man behind the desk. It's not his active thought. It's just that this is what is, habituated to. Here's a police officer who says, just so we're clear, I didn't pull you over due to racial profiling. It's just that most criminals look like you, right? Here's a personal favorite example. This is a picture I took when I was on a flight once. I saw this in an airport restroom. And I thought, oh, this is so neat. I'm going to use this to illustrate implicit bias. And so I went to my daughter, who was 9 years old at the time, and I said, look, honey, look at this picture. Don't you think there's something wrong with this picture? And she kind of looked at it and she's like, I said, you see, like, why is the person who's leaning over the baby suggested to be the mommy? Where is the daddy in this picture? And she paused, and without skipping a beat, she said, well, what if the baby has two mommies? And so there I was, caught in my own implicit bias, trying to demonstrate an implicit bias. So that was really interesting. But the science behind this, I think, is some of this is well known, and much of it is just kind of fascinating from the study of cognition and psychology. So one of the most famous studies, which many people are aware of, is the orchestra studies that were done by C.C. Rouse, who's now, and Claudia Golden. C.C. Rouse now in the Biden administration. This was actually data they collected from the 1950s, actually all the way through 1995, on 7,000 orchestra performers in 588 audition rounds. And what they found basically was that the implementation of blind auditions increased the numbers of female musicians being selected by some 30% in the blind auditions. And so this is a really big effect. Just knowing the gender, right, and eliminating that factor eliminated a certain source of bias. Another famous one are Emily and Greg Moore and Ploy Bolden, Lakeisha and Jamal. This is a resume study where the researchers sent out over 5,000 resumes in a variety of different jobs. All they changed was the name at the top of the resume, exact same resumes, except more Black sounding names versus more white sounding names. And they used two categories of resumes, one with higher qualifications and one with lower qualifications. And here's what they found. Notice that, for in both low versus high, the white sounding names got more callbacks, 50% more callbacks than the Black sounding names. What is so striking, if you compare the top bar with the bottom bar, is that low quality white named resumes got more callbacks than high quality Black named resumes, right? So these are really big effects. Here's a study in education. This was a study actually of undergrads who were told to simulate a teacher and a learner in a certain dyad pair. And these were either same race or cross race. And the teacher was asked to prepare a lesson to teach the learner some concept. And what these researchers found essentially was that the greater the instructor's measure of implicit bias, the lower the test performance of the learner, meaning the learner learned less from that teacher. And this effect was mediated, they found, by the fact that the instructor became anxious in cross-race interactions and therefore gave less effective lessons. And so you can just imagine actually what the social consequences of this is if you think about the fact that still in 2021, the vast majority of the teaching workforce in the United States consists of, they're mostly female and mostly white women. And yet our student body has been majority minority in this country for a few years already. Right? So this is some of the big context that we should think about. This is another study similar to the resume one. This was a study of 6,500 randomly selected professors at 259 US universities, where a mock graduate student sent an email, a prospective graduate student, inquiring about that professor's field of study and seeking information to possibly get involved in that person's field. All the emails were identical, except the names were varied to have white sounding, Black sounding, Hispanic sounding, Indian, and then fifth category, Chinese sounding names. And the question was, what kind of response rates did these names get? Well, the good news is that 2/3 of the faculty members responded overall. So faculty do pay attention to their emails and they do respond. But in every discipline, across every type of university almost, the white male students in this study got higher response rates than all other students. And the most severe bias actually was observed in disciplines that pay the highest salaries and at private universities. Interestingly, Chinese students, the ones with the Chinese sounding names, were the most discriminated against group, suggesting no real benefit to the so-called model minority stereotype. And another interesting finding is that reaching out to someone of the same race or gender, meaning like a Black student name emailing a Black professor, did not reduce the observed disparities. So in medicine, there's a lot of findings in medicine actually, but some of the most interesting ones are regarding pain assessment and treatment. So there are many studies that have found that Black patients compared to white patients are either assessed to have lower levels of pain, or that their pain is not treated with the same degree of either a care or aggressiveness as white patients' pain. In this particular study, this was on medical students and residents. Half of, in a sample of 418 subjects, half of them were found to have endorsed one or more false beliefs about biological differences between Blacks and whites, like statements like Black skin is thicker than white skin, or Black people's blood coagulates more quickly than white people's blood. These are false statements, but half of them believed something like this. And among those who did believe something like this, the more false beliefs they endorsed, the less they accurately rated pain in different cases that were presented to them, and they were less accurate in their treatment recommendations as well. How about professional sports? This is kind of interesting. This just shows like the breadth of areas in which implicit bias creeps in. This was a study of 13 seasons of the NBA, 1991 to 2004, 600,000 foul calls by refs. White referees called fouls at greater rates than Black players, against Black players. And interestingly, Black referees called fouls more frequently against white players, though not to the same extent. And these researchers found that the effects of this, the magnitude, was significant enough to affect an appreciable number of games, given the fact that many NBA games are won by 1 or 2 points. Just one extra foul called can tip the outcome of a game. And complementary study was a 2011 study of Major League Baseball. A data set of 2 million pitches thrown found that an umpire will, all else equal, call a pitch a strike about 1% more often if he and the pitcher are of the same race. The strike calling, is an effect that's not likely big enough to tip many games, unlike the NBA study, but it's still pretty interesting. This one was one that many people know. It's a study about researchers here created local online ads that offered this iPod Nano for sale, varying only the shade of the hand that's holding the item, right? And so what they found is that ads that had a Black hand received 13% fewer responses and then 17% fewer offers than ads that showed a white hand. And then Black sellers were also offered 2 to 4% less money for their iPods than white sellers. Interestingly, there are some geographic variations. So Black sellers were at the greatest disadvantage in the Northeast and at the least disadvantage in the South. They were at no disadvantage at all in the West, according to this study. So the South and the West showed the least. And interestingly, also, when buyers corresponded with Black sellers, they were 44% less likely to agree to have the iPod shipped to them. And they were also 56% more likely to express concern about sending payment via PayPal. Right? This study was followed on by another one by Ian Ayres, Mazar Banaji, and Christine Joles on the selling of baseball cards through auctions on eBay, which found similar results. Okay, how about law? Well, this is going to resonate with what Professor Gorman just told us about some of the pathways that exist in law firms. This was a study about a legal memorandum that was written by researchers intentionally to include 22 different errors, 7 of which were spelling grammar errors, 6 of which were substantive technical writing errors, 5 were errors in fact, based on the scenario that was given, factual errors, and 4 were errors in the legal analysis. And this was a memo that was said to be written by a student at NYU named Thomas Meyer, hypothetical student, fictitious. The only thing that, so this memo was sent to 60 partners at law firms, and the only thing varied was that Thomas Meyer was sometimes said to be white, sometimes said to be black. Well, the partners were asked to rate the memo on a 5-point scale. The black Thomas Meyer got an average 3.2 rating, and the white Thomas Meyer got an average 4.1 rating out of 5. Same memo, same mistakes, exact same product, varying only in the race. And what's interesting about this is not just that subjective evaluation, it's that when Thomas Meyer was black, far more objective errors were pointed out by these partners than when Thomas Meyer was white. So more spelling errors were corrected, more grammar errors were corrected, more factual errors were corrected. And all these errors, the author said, it's like when you're looking for someone to make mistakes, you find lots of mistakes. And when you're not, you're not. And so the subjective comments are also quite interesting on the memo. The Caucasian, Thomas Meyer got comments like has potential, good skills, generally good writer, but needs to work on X, Y, and Z. The black Thomas Meyer got comments like, needs a lot of work, average at best, can't believe he went to NYU, things like that. Okay, closer to the justice system, the district court in this case about the stop and frisk policies of New York found that minorities under the stop and frisk policy are far more likely than whites to be stopped and frisked. But these stop and frisks of Black and Latino suspects were substantially less likely than stops of white suspects to actually uncover weapons or a contraband, right? So in other words, the accuracy of what's going on is less, and this is the way in which implicit bias may be said to impose significant social costs because nothing is being gained from these extra stops and something harmful is actually happening. Okay, the last study I'll show you is this one by Jennifer Eberhardt and a colleague about criminal justice policy. What she did here is she did 2 studies, one of 62 white voters at a Caltrain station in Palo Alto around the time that Prop 36, which was a 3 strikes reform measure here in California, was going on to the ballot. And she asked these voters whether they would be willing to support this ballot measure in 2012. Before they answered, these voters were primed with a rapid series of prisoner mugshots on an iPad, too fast, right, in a sequence for the eye to kind of discern. But one slide deck had 25% Black mugshots, and the other slide deck had 45% Black mugshots. And this is what she found. On the left panel, you see that those voters who are subject to the more Black iPad images said that they would support the 3 strikes reform at far lower rates than those subjected to the less Black images. And she did the same thing in New York City with 164 white New York City residents and found similar effects with respect to ending stop and frisk. And this is so super interesting because in the sense, this is revealing the implicit nature. The priming that she's doing is too fast for the eye to see. The eye doesn't even know what you're really looking at. But the blacker the images, the less likely people are to support criminal justice reform. Okay, well, I'm going to conclude with just a few quick comments about what the ramifications are.
Goodwin?
Yep.
I apologize. I think in order to be sure that we get to Luis and David, I'm going to need to interrupt. I apologize.
Sure. Okay, I'll stop. We can talk about some of the implications if we have any time for Q&A, but mostly just wanted to give a broad overview to give people a sense of the literature behind this phenomenon. Thank you.
Thank you so much. Luis?
Thank you. Dean Chemerinsky, thank you very much for this opportunity Justice Professor Gorman, Professor Wilkins. A pleasure to be on this panel with you. Yeah, and you know, I want to take it in a different direction, which is what happens to us people of color once we're part of the profession or the system. But let me go back a little bit and give you just a snapshot of what California looks like for the legal profession. This was a study by the State Bar of California 2 years ago, the most updated one. At that time, 68% of all attorneys were white, whereas the population of the state of California at the time was 41% white. As far as Asians, 13% of all attorneys were Asian, 15% of the population were Asian. With regards to Latinos, Latinas, at the time, we made up 7% of the attorney population in comparison to 35% of the actual population of the state. And when it came to our Black brothers and sisters, they were 4% of all attorneys and 6% of the population. As you can see there, the Black and Latino representation in this state, especially in the Latinas, is extremely disturbing. And thankfully, these type of discussions lend a different perspective and some light as to what the issues are. And let me we've talked about some of the factors that influence the diversity or lack of when it comes to the profession and professions in general. But let me focus on something different that hasn't been talked about too often, which is what happens to us people of color once we're inside. And as Dean Chemerinsky mentioned, I've been with the Public Defender's Office for almost 26 years now. And right on, I'd say early on in my career, I started noticing an interesting pattern, which was for my Black clients, when they were arrested by Black cops, they were treated a lot more harshly than they were by white cops. Same thing for my Latino clients. They were overwhelmingly treated unfairly or harsher by fellow Latinos than they were by white cops, which sounds kind of counterintuitive. And for me at the time was just mind-boggling because I could not understand how somebody of your same ethnic identity, background could be harsher on you. But then in conversations, and it took me back to my college days when we were being taught about assimilation, that in order to advance, we needed to be just like everybody else. Okay, we needed to put aside the beauty of our culture, of our race, to be able to succeed, because they were looked as obstacles in order to become part of the mainstream. In order to progress, we needed to assimilate. Of course, many of us fought that. We had special terms for that type of mentality. But what I came to see was that that's what these officers were facing. They felt that in order for them to be viewed as competent, unbiased, they needed to overcompensate. They needed to overreact in the way that they treated, if they were Black, how they treated somebody who was Black. If they were Latino, how they treated somebody who was Latino. It was this harsher treatment. And that type of assimilation, ethnic assimilation, was very pervasive in my field, which takes me to what happens to us once we get into the structure, into the mainstream. Unfortunately, what I've seen in these quite a few years now is that when the few of us, people of color, get into a position of authority or influence, or a position where we can make change, many people are either afraid to act, either are apathetic when it comes to advancing the issue of equity. And I'm not talking about diversion or plurality, but really equality. And when we mention the numbers of Blacks in the profession, Latinos, Latinas in the profession, somebody of the same race at times feels like they're constrained because they don't want to be viewed as favoring their own ethnic group. It's what it seems to be. It's this type of ethno-political assimilation that in order to be viewed with respect, to be taken seriously. You have to be completely objective and pluralistic in the way that you view the advancement of other people of color. And that has been problematic because the way I see it, as you look at the pipeline into our profession, there are already many obstacles, many gatekeepers into the profession, whether it's when you get into college, when you get into law school, passing the bar exam, and then getting a job. Along that pipeline, we already have enough gatekeepers. And many of us, unfortunately, sometimes are self-screen. We keep ourselves out for various reasons. So the obligation then lies on those of us. Obviously, we are there because of our hard work and our talent, but also because of the support of partners like Dean Chemerinsky and Professor Gorman, other folks who are not people of color, who are very supportive of these concerns. But once we get in there, the way I see it, our job is not just to be a box checker, not just to check that box, because when you do check that box, you have a certain responsibility to advance, I think, the inclusion of various groups that have been excluded. The difficult part is this. For some of us, it's very difficult to make that change because, like as I mentioned, there's political pressures. I've seen it at the county level where some folks are in fear or worried about their job if they start focusing too much on a specific race, ethnic group. And years ago, I learned from a great mentor, former public defender, the late Michael Judge, who has a very similar approach that Dean Chemerinsky talked about years ago, which is for a white male, it's a lot easier to make these changes than it is for a person of color, because they will not be called that they're being preferential towards Latinos because they're Latino or Blacks because they're Black. They'll be viewed as progressive. They'll be viewed as really opening the door for everybody. And the lesson that I took away is that it's a lot easier for Caucasians to make those changes than it is for us people of color. And therefore, I go back to the same point that once we get into those positions of authority or influence, some of us, for various reasons, sometimes very good reasons, are reluctant to push forward that issue of equity and move away from plurality. Sometimes we have institutional obstacles like Prop 209 that get in the way when it comes to public entities. But there's ways around that. One of the folks here has taught me that you don't announce it, you don't publicize it. You go ahead and do it. You look for ways to get around that problem. So as we're looking for changes, we need to be aware of this, is that this conversation that I'm bringing up has to be brought up to a higher level because it is a stark political reality for those of us of color in positions of authority. That sometimes we need that political backing that we need to make those changes. A current modern day example here in LA County, which is something I'm extremely proud of, we have 4 legal departments for the county: the public defender's office, the alternate public defender's office, county council, and the district attorney's office. Every single one of those offices is being run by a Latina or Latino. Public defenders, Ricardo Garcia; the alternate public defender, Erica Anzuategui; county council, Rod Silva; and our DA, George Gascon. For the largest county in the state of California, the 4 heads are people of color. And just like we can celebrate the fact that we have that type of diversity at such a high level, I, as a person of color, and all of you as well, should not step back and give people a pass if they're not committed to the issue of equity. Because again, some folks may feel a little bit taken aback or worried because of political repercussions. But my position is, once you get into that position of authority or power, it is incumbent upon you, me, to make change. And the way to start making those changes is by having the support of folks around the community. We can continue talking about the lack of diversity in our profession, but if we don't support the leaders who have made it, so to speak, up to those high level positions, then that stream into the profession is just going to dwindle. And that goes for leadership in and outside of county departments. Another example, the State Bar of California, the largest state bar in the United States. The leadership, it's sad to say, and Dean Chemerinsky mentioned it, I was the first Latino president in over 100 years, the first public defender, which is just crazy. And that is still a fact. How can we in the state of California let that happen? There's certain gatekeepers, things have changed, and I'm going to put unofficially Justice Liu on the spot here, but the people who make the call now as to who will become, they call it the chair now, is the Supreme Court, as to who will be the chair of the state bar. We're in positions of authority now. We need to make sure that we continue not just talking about the lack of diversity and the problems associated with that void, but also support those of us who are in those positions of authority. Because without that political support, without that vocal support, it's very difficult for us to make those changes. And the unfortunate situations are those individuals who feel that they've made it on their own, they don't need to do anything else. I mean, that is, it exists in every profession and every walk of life that we deal with. But as we move forward, I just hope that I can bring up to a higher level this discussion of what happens to the rest of us, the ones who are in those positions, and what kind of support we need. Those are some of the points that I want to discuss. I really want to open it up for questions in the back, so I'll turn it over now to Professor Wilkins. Thank you.
So thank you very much. I'm sorry to have missed the first part of this terrific discussion, but I knew a dean would understand that I had to be at a faculty meeting until now. But I'm glad to have caught at least the end of Luis's fantastic remarks, and my friends Goodwin and I should say Justice Liu and Elizabeth Gorman, who are two of my heroes. So I'm gonna just share my screen here, just because I can't help doing that in this Zoom world. And I'm gonna talk just a little bit, and Erwin, you'll jump in if I cannot, if you can't see my slides, about what I've been calling why this is a moment where we need to think about Black lawyers and why they matter. So the little talk is called Black Lawyers Matter, the History of the Civil Rights Movement and the Future of Race in the American Legal Profession in a World on Fire, which I will explain hopefully in just a second. But let's start here. Last night, the House of Representatives passed the George Floyd Justice in Policing Act. Now, let's be clear. The fate of that legislation is uncertain in the U.S. Senate. The House passed a similar bill last spring that died on the vine, and with the exception of South Carolina Senator Tim Scott, it's doubtful that many or even any Republicans will support the bill. But here's what is certain. It's the continuing power of Mr. Floyd's murder to galvanize action in a broad variety of spheres. As his 6-year-old daughter, Gianna, proclaimed at a protest rally on July 5th while sitting atop the shoulders of Mr. Floyd's friend and former NBA player, Steven Jackson, she said, "My daddy changed the world." And here's one thing is clear. The world is changing. I don't have to tell all of you that we are living in unprecedented times with not just one, but two, but three interrelated crises, right? A global public health crisis, a global economic crisis, and an increasingly global call for social and racial justice. And all three of these crises have exposed deep structural challenges that as the Harvard Business School and actually university professor, that's the highest level of professor we have, Erwin will soon be one, Professor Rebecca Henderson argues in an important new book called Reimagining Capitalism in a World on Fire. She says all three of these changes have already set the world on fire and will last much longer than the current sense of emergency has faded. And all three of these challenges have major implications for the legal profession and the role of lawyers in social justice. So just consider a few of the challenges these crises have created. How should we redesign courts and other legal institutions that we know will undoubtedly be in some hybrid form, even after everyone is vaccinated? Or how do we protect fundamental rights like privacy in a world in which these considerations now we know must be balanced against considerations of public health? Or how will we ensure the fair and equal access to everything from government benefits to vaccines, particularly for communities of color? How are we going to jumpstart economic development and ensure that businesses and governments can work collaboratively to develop, navigate, and enforce sensible regulatory policy? And last, but certainly not least, what could we do to advance global governance that promotes global solutions to global problems and ensures that the benefits of globalization are more widely distributed? This last point is of particular importance to me, since my uncle, John Robinson Wilkins, who was the first Black faculty member on the Berkeley Law School faculty and only the second in the entire UC Berkeley system, devoted his short but brilliant academic career to this question. As I recently had the chance to write in the pages of your law review in a festschrift that was just published this past year. All of these things raise real challenges for lawyers. On the one hand, here's the good news for all the students. Resolving these challenges will require new laws and new regulations. We're already seeing an explosion of these. And yet, law is only a part, and often not the most important part, about solving these problems. To address these pressing concerns, we therefore need lawyers who understand the need to provide more than just a service or an answer to a legal question. They, and by they I mean you, the students listening here, need to be a part, but only a part, of creating solutions to complex problems that extend far beyond law. And as this pandemic and the protests have laid bare the deep structural inequalities that underlie all of these current crises, it is equally clear that these solutions must be sustainable as well as equitable. And this means we have to change the way in which we think about social responsibility, beginning with business. Many of you know this famous saying. In 1970, Milton Friedman famously declared the social responsibility of business is to increase profits, period, the end. And although few companies strictly adhered to this famous aphorism, for half a century, few CEOs and even fewer investors and academics disputed the underlying premise that management's primary duty was to maximize shareholder value. And given the power that corporations wield over our society, this idea had dramatic consequences for individuals and society and for social justice in general. Even before the crisis, this taken for granted presumption was being challenged. In 2018, BlackRock, the world's largest asset manager, declared that it would look beyond the bottom line to invest in businesses that, quote, contribute to society. Or take the Business Roundtable. You don't get any more blue blood business than that. followed by amending its definition of the, quote, purpose of a corporation to include duties to all of the company's stakeholders, not just shareholders, including customers, employees, suppliers, communities. And oh, by the way, long-term value to shareholders is important too. And in January 2020, right before the world fell off the cliff, BlackRock issued a second letter saying that it would immediately stop investing in companies that present, quote, a high sustainability risk. By highlighting the deep structural inequalities in everything from healthcare to employment, COVID will only accelerate this trend. And if you have any doubt, in July 2020, the World Economic Forum, even more blue blood corporate than the Business Roundtable, called for a, quote, great reset of capitalism in the wake of the pandemic. To paraphrase a popular TV show, many of you know, Orange is the New Black. I think there's a big argument that green is rapidly becoming the new black. But there's more. Since the death of George Floyd and also Breonna Taylor and many others, it is now clear that racial and social justice must be a part of this broader sustainability agenda. And we see this in everything from the front page of the New York Times Magazine, which had a whole issue on environmental racism, never had seen that before, to the actions of global companies who are putting real resources behind this commitment. Not surprisingly, it started with statements and symbols like banning the Confederate flag at NASCAR or taking this, renaming the Woodrow Wilson School. But companies are now going further, with companies like Google, Apple, Microsoft, PayPal pledging billions of dollars toward funding racial justice organizations, creating hiring and supplier diversity programs, and even floating sustainability bonds, such as Google's parent company's Alphabet's $7 billion sustainability bond, which pledges hundreds of millions of dollars for racial justice and equity. Even major investors are getting on board. Goldman Sachs and the UK Legal General and Investment Management Company have pledged not to support IPOs with all-male boards or to vote against directors of FTSE 100 or S&P 500 companies if there are no Black, Asian, or ethnic minority directors. To stick with the metaphor, maybe Black is becoming the new green. And the metaphor is apt, I want to argue, because it was Black lawyers who first established the connection between social justice and law. Thurgood Marshall and his mentor, Charles Hamilton Houston, who not enough of you know, created the step-by-step litigation campaign that ended up in Brown versus Board of Education, which rescued the promise of American democracy, chiseled on top the Supreme Court of the United States, where Erwin has argued many times, equal justice under law, from the sin and the hypocrisy of slavery and Jim Crow. And for those of you who haven't, you should read Richard Kluger's brilliant book, Simple Justice, about this campaign. But let's not forget that for the first 10 years, Brown's promise was just a, quote, hollow hope, to quote another title from another famous book by the political scientist Gerald Rosenberg. And there was almost no change in the integration of American society in the first decade after Brown, particularly in elite institutions. And just like today, with Black Lives Matter protests, it took mass protests in the streets, led by Martin Luther King Jr., along with brilliant leadership by people like John Lewis or the Reverend C.T. Vivian, who we lost last year, or the incomparable Vernon Jordan, who we tragically just lost this week to force change. And that change came in the basis of legislation crafted by lawyers, the Civil Rights Act of 1965, the Voting Rights Act of 1965, the Fair Housing Act of 1968. These laws, in turn, put pressure on all sectors of American society to finally desegregate, including higher education. And we should acknowledge there has been progress. Look, there was a great book by Erwin written called The Wall Street Lawyer, published in 1969. And here's what he said Wall Street law firms were looking for. They look to recruit men who are Nordic, have pleasing personalities, clean-cut appearances, graduates of the right schools, have the right social backgrounds and experience in the affairs of the world, and are endowed with tremendous stamina. This is not 1869, this is 1969. Today, there are not enough clean-cut Nordic guys to go around. And we all know the profession is far more diverse today. And so is the rest of the United States, which will become a majority-minority country at least by 2045, and in places like California far sooner. And all lawyers will increasingly have to operate in a diverse global environment that will put a premium on cross-cultural fluencies. But the more things change, the more they stay the same. Over 2 decades ago, I published another article in your great pages of your law review called Why Are There So Few Black Lawyers in Corporate Law Firms? An Institutional Analysis. It was the first article in a major law journal to seriously address this topic. And it started from this premise: 4 decades after Brown, Black lawyers still constituted less than 2% of associates and less than 1% of the partners of the nation's 250 largest law firms. There have been a lot of changes since 1996, not the least of which is Barack Obama's election as president of the United States. But after rising slowly for a decade, Black associates have fallen from 4.6 to 3.9% since 2009, with the number of Black partners holding at just 2% since 2012, and some estimates much lower than that. And in 2019, there were 7 firms in the AmLaw 100 that had no Black equity partners and 20 more that only had 1. And while things are slightly better in other sectors of the profession, minorities still constitute less than 12% of the profession, which, by the way, is up less than 1% since 2000. Nevertheless, the Black lawyers who have made it in the door, and Blacks in general who have made it through elite educations, are beginning to make their presence felt. Many of the initiatives I just described around corporate America's response to George Floyd and racial inequity have been made possible by those who were given the opportunity to attend institutions of higher learning by Brown and the civil rights movement, and who now, following Vernon Jordan's example, occupy senior positions with real power and authority in American society. And while their numbers are still small, their voices are increasingly important, particularly with policymakers and C-suite allies who see the unsustainability of the current system, to cite Rebecca Henderson again, what she calls extractive capitalism, where a smaller and smaller share at the top controls an ever larger share of society's resources, destabilizing the very markets and institutions that businesses and the rest of society ultimately need to survive. So here's the challenge I want to leave you with. Will we rise to this challenge and this opportunity? There's no guarantee. We've been down this road before. But I will say this: the forces pushing for change are especially urgent today. COVID has underscored both the interdependence and the fragility of our society. And both the pandemic and the protests have made clear that this interdependence and fragility is fundamentally linked to race and social justice. The world needs lawyers who understand this critical link between sustainability, social justice, and success, and who are building it into their institutions. My parents, Erwin's parents, were framed by the Great Depression and World War II. It changed everything about the way in which they saw the world. I think the same is going to be true for your generation, who are living through these times. You too will be forever changed by it. And the lawyers who recognize this new reality are the ones who will best serve clients and be able to attract the best talent. So the legal profession faces a fundamental choice. It can retrench and retreat to comfortable and established ways, or it can build and expand to meet the challenges of this new future. But institutions like legal professions only survive if individuals like you commit to give them life. In his brilliant and prescient recent book on tyranny, published before January 6th of this year, the Yale historian Timothy Snyder argues this: institutions do not protect themselves. They fall one after the other unless each is defended from the beginning. So he urges this: choose an institution you care about, a court, a newspaper, a law, a labor union, and take its side. And for those of you who will be lawyers, whether you practice or not, I hope you will join me in taking the legal profession side at this critical time in its history by supporting its highest aspirations, but also challenging it to confront its consistent failure to live up to these ideals, particularly around race and social justice. Gianna Floyd,
Thank you.
depending on us.
My thanks to all four of the speakers for the terrific presentations. We've just got a couple of minutes before we have to end, and I received many questions. Let me pull together a few of the questions that go with so many of the speakers say. A number of the speakers have described the underrepresentation of people of color in large law firms. What can be done to change this? Is there any likelihood that it would change?
That's a small question. Listen, the first thing we have to do is recognize that it remains a serious problem. The second thing I think we have to do is to realize that what we've tried mostly so far has not worked, not for lack of effort. Actually, there's been a lot of effort, and there's quite frankly been millions of dollars spent on it, which means that, to quote Darren Walker from the Ford Foundation, we need to throw out the old playbook and think about new ways of understanding diversity and inclusion. There's much more one could say about that, but that is, I think, the path. And Goodwin's work and Luis and Elizabeth's work are all critical for understanding those new pathways.
Elizabeth, or Goodwin, or Luis, do any of you want to address this question?
Just briefly, Erwin, I think part of it has to do obviously with a number of things that have been discussed, but the access point, which is if we get law students to become clerks at some of these firms, establish programs that are going to be proactive with some of these law firms, that they will take these law clerks for the summer or during the school year, is the first step. As Professor Gorman indicated, when somebody feels comfortable around someone, has an understanding, it's a lot easier to commit to that individual. The reality is many students of color cannot afford to work for free. So for the summertime, their choices are limited based on their financial needs. And if one of those financial options is to work for a firm that's going to pay them money, it serves many purposes. So I think that's one thing to consider.
Professor Gorman, Justice Liu, if you had a quick response to this question.
Very quickly, I do think that law firms need to recognize that they can't just rely on informal methods of training and mentoring junior lawyers. That's not going to result in lawyers of color gaining the training, the skills that they need to function at senior levels. But also, I'm optimistic about stereotype-based bias in the long run, because I do think that as more and more people of color achieve positions of authority, such as Luis was talking about in law firms and elsewhere, stereotypes will change, I believe. But I'm a little more concerned about in-group preference and how we can tackle that, because as long as people of different racial and ethnic groups don't have mixed social networks and don't have social ties to people in other racial and ethnic groups, that's going to continue to be a huge obstacle for people of color in this country.
Justice Liu, the last word.
I don't have anything to add on the law firm. I just want to say what a pleasure it's been to be on this panel with such distinguished speakers. And it's wonderful to be in a community that really cares about this issue. And together, I'm sure we are going to make progress on it.
I apologize for the questions. We didn't received a large number of questions, but I cannot thank the four speakers enough for their terrific presentations, for taking time from their busy schedules for this. And thanks to all of you who attended and are watching. Take care, everybody.